Welcome to another webinar from the Center for Agricultural Profitability at the University of Nebraska-Lincoln. I'm Ryan Evans, Communications Specialist with the center, and we're glad to have you here again, and we invite you to check out a schedule of all of our webinars as well as past recordings on our website at cap.unl.edu/webinars. And today we'll be continuing a topic that we covered actually pretty well in the July 17th session on succession planning without a family heir, which was a lot of great steps to take and a great overview of planning for succession without a family heir in the picture. But today, this webinar will focus specifically on strategies for gifting land or assets to non-family members and charitable organizations. And we know there were a lot of specific questions about that when we did this last webinar. So we hope that you find today's informative, and we certainly welcome any questions you have to be typed into the Q&A panel or the chat box as we go. And to present again, we are glad to welcome back Jessica Groskopf, an extension educator and agricultural economist with the Center for Ag Profitability. Jessica is based in Scotts Bluff, and she has authored a whole series of articles on succession planning without a family heir. And we'll be dropping several links into the chat today, so we hope that you find those resources helpful. And as always, the Center for Ag Profitability, we're here to help. So please do reach out if anything comes to mind that you need. And with that, I am glad to turn it over again to Jessica Groskopf. So Jessica, thanks for presenting today.
Thanks for having me, Ryan, and thanks everybody who is joining us. Like Ryan said, my name is Jessica Groskopf. I'm the regional economist out of Scotts Bluff, but I do this work with the other members of our team statewide. So again, we do encourage you, if you have any questions, to go ahead and throw them either in the chat or the Q&A, and we'll try to address those as they come along. Like Ryan said, today we're talking specifically about gifting, and I want to be very clear that I am not an attorney and I am not an accountant. And when we start talking about gifting, I'm today, my hope is to introduce you to some concepts and to some ideas, but ultimately you are going to need to seek your own legal, accounting, and tax advice to execute an effective gifting strategy. So today is for informational and educational purposes only, again, to introduce you to some of the ideas, concepts, and boundaries that we have around this topic. If you have been following along with the article series, or if you participated in our last webinar, we really went through kind of those initial conversations, initial questions related to thinking about navigating succession without an heir. And one of the first things that if you work with someone like me who's helping you navigate that scenario, the first question they should be asking you is ideally, what would you like to happen to your farm or your ranch? So ideally, what would you like to happen? And if you're watching the recording, I would encourage you to pause the recording now and actually take some time to write down your answer to this question. But for the time that we have today, for those of us who are live, we're going to move on from this. But if you haven't spent the time to answer this question, this is very important. It is very important because you are going to be working with a team of advisors who are going to be helping you determine what is going to happen to your assets at your death. And if you don't have this question answered, you have no measuring stick to measure those options against. So this really becomes the guidelines and the guideposts of what options they are going to provide you and ultimately what options you are going to select. So we talked a little bit about a team of advisors. Often when it comes to estate or succession planning, we automatically think of an attorney. And unfortunately, an attorney alone cannot develop a truly comprehensive plan. Likely, you're going to need a team of professionals. So we're definitely going to add a tax professional to that list. Depending on your situation, we might also add a banker or a financial planner, as well as other advisors to really fill out your team. And then what that team is going to do is they are going to help you think through what do you ultimately want to happen and what tools get you closer to that goal. Now, not not every planner or every professional can provide you with the perfect tool because you have a unique situation. Um, and because your situation is unique, not every tool in the toolbox is right for you. Okay. Sometimes I see farmers and ranchers get kind of a block around themselves because they think, well, this did work for my neighbor or that didn't work for a family member. And the reality is that these situations are so unique and that those details will determine whether a tool will or will not work for someone. So I do want you to approach this as being open and going back to your team of advisors, working through those tools and saying, what really fits my unique circumstances as a whole. So again, if you want more detail about these first few opening slides, I would encourage you to go back and watch the July webinar because I spend more time specifically addressing these issues. If you haven't watched that, I do want to go over this just briefly, but again, I probably spent more time on that in July. So as we think about passing our farm or our ranch to someone else, especially someone who is not related, there are really kind of two sides to the coin. There is the estate planning, um, which is basically what happens at the end of your life and at your death. And then there are business plans. And if you intend for your farm or your ranch business to continue on beyond your life, then you probably are going to be utilizing tools or tactics that require additional planning so that someone else can carry that forward. So in the July 17th webinar, we talked about the example of potentially passing your farm or your ranch business on to a tenant or to a neighbor or to an unrelated party. Today, we are going to touch briefly on a couple of tools that are listed here. But when we talk about gifting, really we're talking about removing assets from your estate. Okay, removing assets from your estate. And I'll talk about that a little bit more. I do want to briefly stay I guess I want to remind you that estate planning again deals with the end of your life and with the distribution of the assets that you own at death and distributing those assets to people at death. So an estate plan really contains four components or four documents. You absolutely need a will. A will is, again, that document that says this person is responsible for distributing my assets, and these are where those assets go. You need a power of attorney for healthcare, and a living will or a healthcare directive. These three documents deal with the end of your life when you are incapacitated and unable to make decisions for yourself. So power of attorney deals with business matters, power of attorney for healthcare deals with healthcare matters, and the living will or healthcare directive tells the power of attorney for healthcare what types of care that you want. So when it comes to either power of attorney, you're assigning an agent to help you with those decisions. Okay. So those are the four basic documents of an estate plan. Today, we're going to touch a little bit on trusts. Trusts are not necessary, but you may want a trust. But I also encourage folks to have funeral instructions as well as a list of bequests for personal property. Okay. We're not going to touch a lot on the business planning side. Again, that was covered more extensively in the July webinar. So what are we going to be talking about today? And today we are going to be talking about gifting strategies as it relates to this idea of farm and ranch succession without an heir. So there are several cultures that kind of have this theology of it is better to give with warm hands than with cold ones. And so we really are talking about, again, gifting while you are alive, rather than passing those assets through a will or through a trust after your death. So again, I'm going to be focusing on that component of it. Of course, you can make bequests within the will or within the trust. But again, that was probably covered a little bit more in our last webinar. Okay. All right. So let's start out by determining what a gift is. And I think this is really important. I think sometimes we don't always include everything that could be considered a gift. So a gift is a voluntary transfer of property from one person to another person for less than full consideration. Well, Jessica, what does that mean? Okay, so I'm giving something to you of value, but I'm asking for less value in return, right? So the most obvious thing is true gifts, which are I'm going to give this to you for no return, right? But we can also think of things like below market loans as gifts. So we have to be very clear when we're setting up a gift that we know and understand that it's a gift. So if I'm giving someone something for less than basically fair market value, I'm potentially giving them a gift. Okay. And your accountant and your attorney are going to guide you through these gifts. The one that I see most farmers and ranchers skate over are those below market value loans. Okay. So a couple of other components of a gift. The giver must have the intent to make a voluntary transfer. So that transfer is not forced. The giver must be competent to make those gifts. The receiver must be capable of receiving those gifts. And the giver must actually depart with dominion and control over the gifted property. You must lose control over the property. Okay. This is very important, especially when we talk about from a tax perspective, that you basically don't have strings still attached to that gift. So today I'm going to focus on complete gifts, which means complete loss of control or full loss of control of that asset or that property. There are things that are incomplete gifts. And the way that we think about an incomplete gift is the ability to change or modify the beneficiary of that gift. So, revocable beneficiaries on a bank account is a perfect example of that. Um, Beneficiaries in a revocable or a living trust joint bank account technically are an incomplete gift until the non-contributing party withdraws those funds, and then gifts with reversionary interest. So again, if there's some sort of string attached to that gift. Okay. So again, to keep it simple, I'm going to be talking about complete gifts. So again, where you gift that asset to someone else and you no longer have control or decision-making power around that gift. So when it comes to gifting, there's a lot of questions regarding how are gifts taxed. So I'm going to go through some of these examples and some of the considerations that you need to be aware of as we talk about taxes as they relate to gifts. So first and foremost, if your spouse is a US citizen, there are no tax on gifts between spouses. So my spouse and I can gift each other as much as we want. There's no tax there. If they're not a US citizen, there are some limitations on how much you can gift them tax-free. Again, work with an accountant if you are in that situation. But if they're a US citizen, we can give unlimited gifts. There are no taxes on gifts to political organizations or charities. Okay, I think those are pretty straightforward. For charities, they do need to be 501c3s or 501cs. Okay, you can also gift to federal, state, and local governments for public use. Okay, I think some things that sometimes get skipped over is we can also have no taxes on something called qualified transfers. No taxes on qualified transfers. So these are payments directly made to education institutions or medical care providers for qualified expenses. So I often see celebrities doing this, and they get kind of a big news splash about, a celebrity went to a medical facility and they paid a bunch of medical bills. That is a non-tax gift to those people. Okay. So there's a reason they're doing it. It's a qualified transfer. What's interesting about this is You can do it for related or unrelated people, but it has to be for qualified expenses. So if you're interested in doing this, most educational institutions and medical care providers will guide you and let you know what a qualified expense is. So the example on the educational institution standpoint is tuition is a qualified expense. So if you wanted to gift your children or your grandchildren, you could pay their tuition at an educational institution and pay no tax on that gift. Okay. The other thing is we have what's called 529 plans. 529s are thought of as college savings accounts. And there's actually a place where you can contribute up to 5 years worth of the annual exclusion tax-free at one time. Again, I would work with a tax professional and a 529 plan coordinator to do that gift, but there's no tax on those gifts. So these are the things that are non-taxable. So if we're gifting to charities or political organizations, there's no tax on that gift. And then we need to get the details and work with those institutions when it comes to qualified transfers and 529 plans. Okay. So the next piece that we need to understand is, okay, so what is taxable? If all of that's not taxable, then what is taxable? And there is on the federal side, okay, we're talking about federal here. On the federal side, we have the estate gift tax exemption. So the federal gift and estate tax exemption. Sometimes you'll hear this called the unified tax credit, okay? And basically what it states is that the federal government taxes the transfer of property the same regardless of whether that transfer is made during your life or at death. Okay. Now remember, we're only talking about the federal level here. However, there are several exemptions here. The first exemption is called the annual exclusion. In 2025, the annual exclusion is $19,000. Okay, so basically what that means is that I can gift $19,000 to anyone that I want to. It's cumulative over the year, and I can gift them that. Okay, and I'll go through another example here in a little bit, but I can give up to $19,000 per person per year to anyone that I want to without filing with the IRS. Okay. The other piece here is that estates above a specific amount will be taxed at 40%. In 2025, that amount is basically 14 million. In 2026, it will be 15 million. Okay. So when you pass away, if your estate is larger than we'll assume that you survive the rest of this year. If your estate is larger than $15 million, it will be taxed at 40%. Okay. I'm going to go through both of these exemptions in an example slide here next. Okay, so let's talk about the annual exclusion a little bit more in depth. So the annual exclusion again this year in 2025 is $19,000. The limit applies to all gifts given to the receiver of those gifts. Okay, so a lot of tax accountants or tax professionals will say go a little bit less than the annual exemption because that would include birthday gifts. Everything else should technically be included in that $19,000. You can gift the annual exclusion to as many people as you choose, and you do not have to be related to them. So if I was just feeling overly generous today, and I wanted to gift each of you $19,000 who are on this webinar, and I had the means to do that, I could gift each of you $19,000. Okay. There's really there's really no limitation to the annual exclusion amount as long as I don't exceed that $19,000 combined of the gifts that I provide to you. This is a use it or lose it exemption. The annual amount is determined and is inflated every year. Like I said, this year is $19,000. I haven't seen the 2026 number, but within 2025, I can gift $19,000. And then come January 1, 2026, I can gift whatever the amount is for 2026. But I cannot say, well, I didn't give it in 2024, so now I can add that. That's not how it works. You either use it this year or you don't. Okay. And again, if you gift someone utilizing the annual exclusion, there's no IRS filing requirements. So here's an example. A husband and a wife have 3 adult children who are all married. So there are 3 children and 3 spouses. So that's 6 people. The husband can gift each of those 6 people $19,000, transferring $114,000 worth of wealth. The wife can do the same, again, transferring another $114,000. So in a single year, if this was the situation you were in, they could transfer almost $250,000 in wealth in a single year without reporting to the IRS and without impacting their estate and gift tax exemption amount. Okay, so again, this does not count towards in 2025 what is the 13.99 million. Okay. So again, if you are in this situation, be thoughtful about who all you're giving this exemption to, this exemption amount to. This does not necessarily have to be cash. It could be value. We are seeing more complicated tactics where people are gifting things like LLC shares, utilizing the annual exclusion. Okay, it could be cattle, it could be other things, but you need a team to advise you on how to do this correctly. Okay. The other piece here is that you're losing control of that asset when you do this. So please don't forget that you can't say, here's your $19,000 and I would like you to spend it on this. It's not how it works. You are losing dominion and control over the gift that you provide to whoever you decide to gift it to. Okay, so the other one is the state and gift tax exemption amount. And this is really interesting. So we were waiting for the One Big Beautiful Bill Act to come out because we were waiting to see whether or not the current exemption amount would become permanent law or would sunset back to a much lower level. And the act did make permanent the higher level of the estate and gift tax exemption amount. So for 2026, it will be $15 million. The reason I say permanent, right, it's permanent until lawmakers decide to change it. And this is something that has had variation in it. We have been in this higher realm for a while now. And to be honest, most estates do not exceed this $15 million allowance. But I still want to go through it. There may be some of you who are on here who are in a place where maybe you do have more than $15 million worth of assets. Now, remember that this is $15 million per person. So if an estate is set up correctly between a husband and a wife or between spouses, they could essentially pass $30 million without paying estate and gift tax, federal estate and gift tax. Okay, so it has to be properly structured. The other piece here in a part of structuring it correctly is that we do encourage you to elect portability of unused exemption. So let's say we have spouses, one of the spouses die, and maybe they don't pass the full 15 million when they pass away. So you can take whatever of that 15 million they didn't take and pass it over to the surviving spouse. So that when they pass, they have a little bit more than what the current threshold is. Okay, so that's called electing portability. We encourage you to consider electing portability, especially if you are in a higher asset value range. For any gifts that are larger than the annual gift tax exclusion, so let's go back to this. So that's $19,000 in 2025. If you spend more than if you gift more than $19,000 in 2025, what happens is then we are kind of chipping away at the federal estate and gift tax exemption. So if I gift more than the $19,000 in 2025, I'm basically counting against this year what is 13.99 million if I were to pass away with. Does that make sense? So if I gift more than the annual exclusion, I need to report that to the IRS because of this estate and gift tax exemption amount will be lowered by the amount I went over my annual exclusion. Okay, that doesn't necessarily mean I will be taxed on that amount. It means that when I pass away, the amount that I'm able to pass tax-free will be reduced by the gifts over the annual exclusion that I have already given. Okay, so here's the example, and I think this outlines it a little bit more clearly. So again, this is the federal gift and estate tax exemption. If I have a farm worth $5 million and I gift this farm to my tenant in 2025, this is a non-exempt gift that I made during my life. Okay, this is the only one I made. So this is the only thing that is counting against the federal estate gift and estate tax exemption for me. I will have to file a 709. Then when I pass away, my federal gift and estate tax exemption will be lowered by the $5 million gift that I've already given. Okay. So it's complicated. I encourage you to work with a team to do this. But you can gift assets during your life and still manage the federal gift and estate tax. Okay. Be thoughtful about it, know how it works, but this is an example of that. Okay. The other tax consideration here for those of us in Nebraska is the wonderful Nebraska County Inheritance Tax. Okay. So in the state of Nebraska, assets that are passed at death are subject to inheritance tax. Remember that inheritance tax revenue goes to your local county. It's a very important part of county budgets. But for those of us without heirs, this is really important because most of us without heirs are probably going to gift assets to more removed relatives and to non-related parties. And so we can see that the Nebraska inheritance tax goes up and the threshold for what isn't taxed gets smaller. So in other words, the more distant someone is to us that we're passing assets to, the more they're going to pay a Nebraska inheritance tax if we wait to give those assets to them until death. Okay. So again, work with your team to discuss the impacts of Nebraska inheritance tax, especially if you are considering gifting these assets at death rather than during life. Okay, other considerations. So what is the value of the gift? So we've decided, maybe we want to do some giving. Maybe we're trying to reduce the size of our estate, or maybe we just want to give with warm hands. How do I determine what the value of that gift is? So for gift tax purposes, the value of the gift is equal to the fair market value of the gifted property on the date of the gift. Fair market value on the date of the gift. You may need an appraisal, especially for property, so that we can determine what that asset value is. There are discounts given for what they call lack of marketability, liquidity, and control, particularly for closely held businesses. So again, we can use an entity or a business structure to potentially lower the value of that gift because that person is receiving minority interest or minority control of that asset if it's within the entity. Okay. For those of us who have large estates, there are tactics related to gifting that are important. So if you think that your estate will be worth more than 15 million if you're single, or 30 million as a couple. We really need to discuss with our team this strategy. And these are just related to gifting. There are other strategies that are available. But first is making complete gifts. So if you are going to use gifting as a strategy, you need to make sure that you don't have any strings attached to those gifts. You need to give away full control of that asset. You're going to maximize your exemptions, so gifts to political organizations, charities, and qualified expenses. You're going to utilize the annual exclusion every year to as many people as you want. And one of the really big tactics is making sure that you are gifting appreciating assets out of your estate. Okay. Now, there are some drawbacks to this, and we're going to discuss those next. But if you are sitting in a situation where you will have a relatively large estate, these are some of the things that you can do to help minimize that estate tax if you feel like you will be subject to it. Okay, so what are the drawbacks to giving? And I've talked about it before, and I want to re-emphasize it again. The biggest drawback to gifting assets is that you must lose control of that asset. Having strings attached to that asset means that the gifting tactic, if you're using gifting as a way to reduce federal estate tax, may work against you, because they could claim that no, it really wasn't a true gift. You still had some sort of control over that asset. So when you gift an asset, it needs to be a true gift and loss of control. Okay. That is hard for some farm and ranch families to swallow. So if you gift an asset and the person you gave it to turns around and sells it, that is their right and that is their choice if it was a gift. And that's hard. Okay. So just be thoughtful what you're gifting, why you're gifting it, and making sure that you trust that person to be a steward and a shepherd of that gift. But you cannot dictate, in most cases, how they manage that gift. Okay. All right. So let's talk about tax basis within the property. When a giver makes a gift of property to the receiver, we establish what's called tax basis. So what's interesting about giving gifts is if someone gave me a gift, I receive their tax basis in that gift, not the fair market value of the gift. So tax basis is different than the value of the gift. Okay. So if you don't want people to sell property, gifting can be an encouragement for them not to, because they would have to pay a significant tax on that if it had a low basis property. So for example, some farms and ranches have a history of gifting land to the next generation, which means that the tax basis in that land is very, very low, which means if they sold it, they would have to pay a significant amount of taxes, and it incentivizes them not to sell that gifted property. Now, that might not be enough to incentivize them not to sell the property, but it is a big consideration of it. So I have an example for you here. You have an adjusted basis in land of $400 per acre. On the day you gift the land to the receiver, the land is worth over $3,500 per acre. If the receiver sells that land for more than $400 per acre, they may be subject to capital gains tax. Okay. All right. In other words, gifts do not receive the step up in basis. A lot of farm and ranch families, especially those without heirs, who expect heirs to, or whoever receives it, we'll talk about like non-farming heirs. If they expect them to sell that asset relatively quickly following your death, you're probably going to leave that asset in your estate so that whoever receives it gets the stepped up in basis and does not have the issue with capital gains. Okay. My colleague Anastasia Meyer has a really nice article about the stepped up in basis, but remember, gifts do not get the stepped up in basis. Okay. Now, capital gains taxes are some of the most favorable taxes that you will pay. It's either 0, 15, or 20%. It's more favorable than income tax rates. And remember that not all gifted assets are subject to capital gains. Some are taxed at ordinary income levels. So again, you need to work with a team to know what asset has what tax implications to it and how the gifting will affect that. Okay. The other drawback related to gifting are look-back periods for federal estate tax and for Medicaid. Okay. Medicaid is different from Medicare. So we're talking about Medicaid is for low-income individuals, particularly who need long-term care, is something that happens. There is a 5-year look-back period for people who are entering long-term care utilizing Medicaid. So that means prior to entering long-term care, under Medicaid rules, those assets that were gifted within 5 years of that may be included in your ability to pay. Okay. There are other challenges with trying to qualify for Medicaid and utilizing Medicaid. There's a limit to the amount of assets that can be owned. And there's, especially in rural Nebraska, limited facility choices. So again, you need a team to help you plan for long-term care. And if you are utilizing gifting as a part of that planning process, it needs to be done at least 5 years in advance of you entering long-term care. Federal estate tax also has a 3-year look-back period. So again, gifting strategies often have a very long runway because any gifts within that 3 years may be included in the calculation of the federal estate tax. Okay. All right. I'm going to take a deep breath there. We're finally to the portion about gifting to charities. And again, here we're going to focus specifically on charities. Remember, there are no taxes on gifts to charities as long as they are federal, state, or local government that's using that item for public use, a 501c3 or a 501c. Okay. So when it comes to gifting to charities, there's also potentially the benefit of an income tax deduction. In order to reduce your income taxes, you must itemize deductions, which means you're probably gifting more than the standard deduction, and the standard deduction depends on how you file. So for married filing jointly, that's $30,000 or more in 2025. There's also limitations to the amount that you can gift, and that depends on the classification of the charitable organization and the type of property that's contributed. Some farms and ranches want to donate tangible property, and how the value of that tangible property is determined depends on whether that's of a related use to the charitable organization or a non-related use to the charitable organization. So again, you're going to need a team to help you figure out what your value of that tangible property would be in a donation situation, depending on whether or not that charity can actually use that asset or not, okay, as a related use or not. Okay, my biggest piece of advice here when it comes to gifting to charities is to work with their donation offices. They all have lovely people who know a lot more about this than I do, and know a lot more about what types of gifts they need. So we can think about one-time gifts, or we can think about reoccurring gifts, and some of them are also able to handle charitable trusts or help you set up charitable trusts. So I do want to take a minute to talk about trusts, and I'm only going to be discussing this today from a charitable giving standpoint. And I'm also just going to be introducing the concepts Again, I encourage you to build your own team who can help you through this process. So what is a trust? A trust is a separate entity. I like to think of it as a bucket that holds assets for the benefit of someone else. You'll hear a lot of people talk about funding the trust, and that simply means retitling assets or property to the trust. Okay, so if I have a farm, I would put it and retitle it to the trust. Or if I had bank accounts, they would go into the trust. You, as the person who is setting up the trust, define the rules of how the assets are used and when they come out of the trust. Annual payments can be made to the beneficiaries of the trust. And I think one of the biggest misconceptions about trusts, especially here in Nebraska, is that trusts provide privacy. Unfortunately, that's not the case in Nebraska because we have inheritance tax. Basically, your estate will still be public record because you still have to pay the state inheritance tax. Okay. So a trust has three parties. There's the grantor, which will be you putting things into the trust. The beneficiaries are the people who are benefiting from the trust. And today we're going to talk about income beneficiaries and remainder beneficiaries. And then there's going to be the trustee, which is the person who is managing the trust. There's also a definition called the remainder, which is the assets left in the trust at the end of the trust term. So the remainder beneficiaries will receive the remainder of the assets left in the trust. Okay, I'm a very visual person, and I was going to dig out my bucket today, but I forgot to. Here's kind of how a trust works. I could be the grantor. I determine what goes into the trust, what happens to the trust. There's then an income beneficiary. So while the assets sit in that trust, someone can benefit from the income generated by those assets. And then at the end of the trust term, there's the remainder beneficiary who receives what's left over. Overarching, there's the trustee, who's the person who's managing the assets within the trust for the benefit of the beneficiaries. When it comes to charitable trusts, there are a couple different types of charitable trusts. You might hear of pooled income funds, charitable remainder trusts, and charitable lead trusts. So a pooled income fund is a single trust where there are lots of people who are putting contributions into a single trust for a single charity, and then each donor receives their share of the income of that trust for life. Okay. Charitable remainder trusts are irrevocable trusts that allows one person to contribute, or I'm just going to say one person to contribute assets to a charity while retaining the rights to receive income from those assets for a set period of time or the donor's life. And then at the end of that trust term, the remaining assets go to the charity. A charitable lead trust says that the income beneficiary is the trust, and the remainder beneficiary, usually a family member, is then the remainder. So again, I'm a visual person. So pooled income funds and charitable remainder trusts kind of look like this. You give into the trust, you may receive income from that trust, and at the end of the trust term, then the charity gets the remainder. Charitable lead trusts are a little bit different. You put assets into the trust. The charity receives the income benefits during the term of the trust, and then the remainder goes to a non-charity person, usually a family member. All right. Let's wrap up a little bit, and I see there's a couple comments and questions coming in through the chat. Again, if you have comments or questions, please go ahead and put them in the chat or the Q&A, and we will wrap up today answering those questions. So if you are considering a gifting strategy, I really encourage you to ask yourself, why are you gifting? What are you gifting? And are you gifting the right asset to the right person or organization for the right reasons? And are you confident that you can truly lose control of that asset and that your spouse or heirs don't need that asset in the future? Okay. Once you've kind of answered these questions, you really do need a plan. And I cannot emphasize enough when it comes to um, a strategy. I think a lot of us just maybe avoid gifting because there's a lot of things to think about. But if we are serious about gifting, especially if we're serious about gifting property, we really do need a strategy. We need to know that we know that we know that we have the tax portion of this correct, and that we are not causing issues on the other side. So again, I would encourage you to get together with your team. Again, this team needs to be more broad than just an attorney. You need an attorney, an accountant, and potentially others who can assist you with this process. So I'll put up my contact information here at the end for a little bit. And Ryan, if you have any questions, let's go ahead and take some of those.
Hey, thanks a lot, Jessica. Great presentation. We've had several comments through the chat of people identifying with what you're talking about and thanking you for the information. Certainly, if anybody has questions, now's the time to type them into the Q&A or the chat, and we'll be happy to try to answer those. We've got a few minutes left here, and if anything comes to mind after you leave, you certainly see Jessica's contact info there on the slide, so you can follow up with her. So one question that just came in asking if the basis of value change, or excuse me, if when passing farm property with life use, does the basis of value change for the beneficiary?
So I think we'd have to go back to, I think what you're talking about is, I'm not sure what you're talking about on that verb with life use. I think what you're talking about is a life estate deed. So correct me if I'm wrong. Does the basis of value change with the beneficiary? Change for the beneficiary? I would have to refer to an accountant or an attorney to know the answer to that, and also a little bit more details if you are truly talking about a life estate deed. And I think the article from Anastasia also might address that particular issue. But if you want to, why don't you shoot me an email or put your email in the Q&A, and I will follow up with you on that directly, because that is a good question if I'm interpreting your question correctly. So if it's a life estate deed, does the value change? I would need to find the prop. I think I know the answer, but I want to double check that answer before I state it out loud. So feel free to stick your email in the chat and we'd be happy to answer that for you.
Great. Thank you, Jessica. And one more time, I'm going to put that article on stepped up basis into the chat as well, again, in case anybody missed it. And if anyone else has questions, please do type those in now. Got a few minutes left. Jessica, this is something we talk about a lot, but I guess it can never be mentioned enough. And just some of the comments in the chat have reminded me of this. If somebody's never had this conversation about legacy or planning, what's a good place to start? If you can just review that again, maybe.
Yeah, so I think it depends on where you're at. When it comes to younger producers, especially if you're coming back into the farm or the ranch business, I always encourage them to write a letter to mom and dad asking for more information about what the plan is and whether or not they can get something in writing. I think it's a little bit harder when we talk, especially about that silent generation, about getting them to discuss where they are at. And some with that older portion of the boomer generation also kind of has this um, cultural component to it of, it's my business, not yours. But I think there are some important things that, can be discussed of, I don't mind what happens to the assets, but I want to make sure that particularly your health is taken care of, that if you became incapacitated, that the business pieces and components were taken care of. So I think it depends on your relationship. If you're struggling, I encourage a letter. But having these small conversations, I think is really important. That's why the last slide today is small steps every day. I think I don't necessarily think that intervention talks really work with folks. I think it's those small conversations time and time again that really do help.
Great. Thanks, Jessica. And there's a reply back in the Q&A if you want to take a look at that. I don't know if we want to touch on that, but I want to thank everybody for joining us. And again, we still have time to answer a couple questions if you want to get those in while Jessica's reviewing a couple things. As you close out of Zoom today, when you do go, you'll be presented with a very quick survey. If you don't mind taking the time to answer that, it should just take 30 seconds or so of your time to let us know how today went and any ideas you might have for future webinars from the Center for Ag Profitability.
Well, Ryan, I'm not seeing any more.
Yep, I think we can call it a day on this one. So again, you see Jessica's contact info there on the slide. So if you want to take that down in case something comes up, or as always, feel free to reach out to us here at the Center for Ag Profitability, cap.unl.edu. As I mentioned in the chat, this recording should be posted in the next day or so, and that will be at cap.unl.edu/webinars. Margaret, I'll follow up with you and we'll see if we can get that for you. And thank you everybody for attending. Jessica, thanks for a great presentation today, and we'll see you next Thursday for another webinar.
All right, thanks.
Take care, everyone.